Hi, this is Sean Henricksen from the Sean Henricksen Law Firm, where we help good people like you avoid the devastating consequences of criminal charges. Today, I'm going to talk to you about why you shouldn't take trial off the table right now. Before I get to that, I do have a free download for you. It's 4 things you should be doing right now if you're charged with a criminal offense. If you look down in the notes, you can click on the link down there and I will email that out to you for free. I've got a lot of people who come in who are being charged with a crime, and one of the things that they'll tell me is that they don't want a trial. And right now, I want to talk with you about that and tell you why you shouldn't take that option off of the table quite yet. There are a lot of reasons why you may want a trial, or at least you may want to consider a trial. One reason that you may want a trial is because you're innocent. If you didn't do what you're being accused of doing, you should be prepared to take your case to trial and have a jury make that decision and hold the state to its burden. And what I mean by that is that the state is the one who has to be able to prove beyond a reasonable doubt that you did something. If they can't prove that because you didn't do something, then you should be ready to take that case to trial. Another reason you may want to think about going to trial is that you may have a winnable case. If the state has a weak case against you and they may not be able to prove that you did something beyond a reasonable doubt, then you should be prepared to go to trial, or at least keep that as one of your options. Again, it's the burden of the state. They're the one that have to prove that you do it. They may not have the evidence, or maybe they can't get the evidence in to be able to show that you would do something. A third reason you may want to consider taking a case to trial is if you just have a bad offer. If the state is making an offer to you, but it's likely that you are not going to get anything worse and may even get something better if you do go to trial, even if you lose, then it doesn't make a lot of sense to take an offer from the state. A big example of this are misdemeanor family violence cases. A common offer here in Bexar County for misdemeanor family violence cases is for a period of probation, sometimes with deferred adjudication, sometimes with straight probation, meaning that there's already a conviction. In Texas, there's not that much of a difference between the two on family violence cases because you can't get your record cleaned up, which is the main benefit of deferred adjudication. So any type of plea that you take is going to show up on your background check for the rest of your life, and you'll end up on probation. If we compare that to what happens in most misdemeanor family violence cases that do go to trial, even when people are found guilty, they still usually end up on some sort of probation. And probation, whether it's straight probation or deferred adjudication, like I mentioned, there's just not that much difference in Texas on a family violence case because of the additional consequences of family violence cases. If you have any questions about what I've said in this video, or if you'd like to discuss your case with me, feel free to give me a call. My phone number is 210-942-4997. I'd be happy to discuss everything with you, and I hope that you have a great day. If this video has been helpful to you, I definitely appreciate you liking the video and subscribing to it, and I hope you have a great day.